Hi, folks. This is Anthony Ania of Ania, Scanlon, and Serignano. Hope you folks are doing well and everybody is healthy and good health and staying well. And again, Anthony Ania from Ania, Scanlon, and Serignano. Hope everybody is doing well and enduring, I guess, week 7 or 8 of the pandemic. You kind of lose track of what day it is when you're not going into the office and not running around every day. But hopefully everybody's doing okay, and it looks like we may have the worst of this behind us. So let's keep our fingers crossed and keep praying, as they say. So today we're going to talk about using trust to avoid the pitfalls of probate. And for many years, trusts have been around. They've been available for people to use for decades. And in fact, many of the affluent in the country have always made good use of trust planning and using trust. But somehow or another, generally middle class individuals, even upper middle class individuals, have not used a trust as a vehicle to do their estate planning and other types of planning, whether it be for children, etc. They've tended to use a last will and testament, and that has really been the document of choice for most attorneys for many, many years. There are a lot of reasons why attorneys recommend last wills and testament. Uh, Most of the reasons have to do with the fact that once the individual dies, there is probate, which is another potential legal fee for the attorney who handles the probate of the estate. My position has always been that I felt that a revocable living trust is really a much better vehicle to do planning than a last will and testament. And I think there's a lot of reasons to want to use a revocable trust, and I'm going to go over some of them with you today. So, what is a revocable trust? Obviously, it's a writing, and it's often known as a revocable living trust. It's a written agreement between the creator of the trust, also known as the grantor, and the trustees or co-trustees. You don't have to have co-trustees. You can be, in New York, the creator of the trust and the sole trustee of the trust. So you can be both the person that creates the trust and be the sole trustee. And the trust is an agreement between basically yourself. And the terms of the trust document control what is going to happen with the assets that are titled into the name of the trust during your lifetime and on your death. So envision the trust like a candy holder. So the trust is like a container. And until assets are retitled into the name of the trust, the assets are not in the trust. So funding the trust is critical, right? So if you own a house, you have a brokerage account, you have bank accounts, those assets, in order to be affected by the trust, have to be retitled in the name of the trust. So if you have a house and bank accounts and you want your trust to control that, you have to basically retitle the house, do a new deed, transferring title to the trust, and then you would need to go to the bank or brokerage firm and retitle the bank accounts and brokerage accounts to the name of the trust. You wouldn't transfer your IRA or 401k to the trust because an IRA or 401k generally has named beneficiaries, and on your death, the assets in the 401k or IRA pass by operation of law to the named beneficiaries of the account. So they would go automatically to the beneficiaries that are named on the account and any alternate beneficiaries. For those of you that have IRAs or 401ks, it's very important to look and see that you have named individual beneficiaries on the account and named alternate beneficiaries on the account as well. Because if you don't, then when you die, the assets in the IRA or 401k will become payable to your estate. So let's say you're a husband and wife and you have your wife named as the primary beneficiary, but on your date of death, your wife has predeceased you and you have no children and you did not name any alternate beneficiaries. Then that IRA would pass to your estate, which would either be controlled by your will, if you have a will, and if you don't have a will, it would be controlled by the laws of intestacy. It would pass to your heirs. However, because it is an estate asset, the IRA, which is normally not available to creditors, right, would now be subject to creditors' claims, including Medicaid. So it's very important to have named beneficiaries and alternate beneficiaries on your IRA or 401k. So now you want to do planning. You want to do estate tax planning, or you want to just have assets distributed to certain individuals when you die. Well, you create the revocable trust. If you're single, you can be the sole trustee, or if you're married, you can be a co-trustee with your spouse. And now you transfer your assets to the trust. During your lifetime, you have full control over those assets. You can do whatever you want with the assets in the trust, the income, the principal. You can sell them, you can buy them, you can dispose of assets, you can add assets to the trust, you can remove assets from the trust. It is a revocable living trust. Revocable means it can be amended, it can be modified up until the death of the creators of the trust. Once the trust creators, the grantors, pass away, then the trust terminates. It becomes irrevocable at that point in time. So, from the perspective of managing your assets during your lifetime, now you have this vehicle that you utilize to manage your assets. You've created the trust, it's fully signed and executed. You are the trustee or a co-trustee, and now during your lifetime, the assets in the trust are controlled and managed by you. The trust also specifies what happens with those assets upon your death. They could go to individuals outright. They can go to individuals in trust. All of the estate and tax planning that you can do in a last will and testament, you can also do in a revocable living trust. So, for example, if you're a high net worth individual and you want to do a credit shelter trust, you can create in your revocable living trust a credit shelter trust, or you want to do a disclaimer trust that says everything goes to your spouse. However, on your death, your spouse can decide whether or not he or she wants to take those assets for estate tax planning purposes. So everything that can be done in a will can be done in a trust. The assets that are transferred to the trust during your lifetime, they're taxable and treated the same way as you own the assets. In fact, a revocable living trust does not even require a federal ID number if you are both the creator of the trust and the beneficiary of the trust. So it continues to use your social security number. So you have the assets in the trust during your lifetime, you're managing the assets, you're paying your bills, your checking account would presumably be in the name of the trust, your savings account in the name of the revocable trust, your house in the name of the revocable trust. And you're managing these assets just as you would normally do, except they are titled in the name of the revocable living trust. During your lifetime, if you become incapacitated or disabled, the alternate trustee that's named in the trust has the ability now to step up and basically manage your affairs under the terms of the trust. So with respect to the assets that are in the trust, in the name of the trust, the alternate trustees or co-trustee can continue the management of the assets, and he or she does not have to run to the bank with the power of attorney. All they have to do is present perhaps a letter from a doctor that says that you're incapacitated or disabled, and now continue to manage the trust. So this is another advantage of using a trust, is that in the event of incapacity or disability, the co-trustee or the alternate name trustee of the trust, and again, the trustee is the fiduciary. He's the person that manages the assets in the trust, and you can be that person. You can be both the creator and the sole trustee or a co-trustee. So sometimes, for example, husband and wife, they'll be co-trustees. Sometimes they'll be sole trustees. It depends on their preference. Some of our older clients prefer to have a child or two children named as co-trustees, so that in the event that something happens to them, those co-trustees can immediately step in and manage the assets in the trust. So from the perspective of planning, lifetime planning, excellent vehicle. gives you that continued control during your lifetime. And then if you become disabled, the alternate trustees can continue to manage. What happens when you die? And this is really the big advantage of a revocable living trust, is in the event of death in the event of death. What happens then? On death, the trust terminates, but unlike a last will and testament, the trust does not have to go to probate. The trustees of the trust do not need to go file the trust with the court, do not need to commence a probate proceeding, because the assets are titled in the name of the trust, and now those assets will go to the named beneficiaries under the terms and conditions specified in the revocable trust. So the trustee's job at this point in time, at death, would be to basically make sure that all the assets are in the trust, pay any outstanding bills, estate taxes, whatever the case may be, funeral bills from the assets in the trust, and then basically do an accounting, or if they need to do, if the trustees are all the children and they consent, they don't even need to do an informal accounting. They can just send copies of all the account statements to the children and now make the distributions of the assets to the trust. No court filings, no need to go through the expense of filing a probate petition with the court. There are filing fees with the court. There is no delay in terms of making distributions. The distributions are made by the trustees once the expenses have been paid. There is no possibility, unlike with a will, that, for example, you may have a disabled beneficiary. And if you have the probate of a will with a disabled beneficiary, the court will appoint a guardian ad litem. So if you have a child or a grandchild that's a beneficiary under your will and they're a minor, or they're disabled, the court would want to appoint a guardian ad litem to protect the interest of that beneficiary, to make sure that that beneficiary, under the terms of the will, is going to get what they're entitled to. Well, that again slows down the process. Even with a court like in Westchester County, the surrogates court, which is relatively efficient court, a very good court, still the entire probate process from beginning to end can take anywhere from 9 months to 1 year to complete the probate process and distribute assets. That is not what happens with a revocable trust. The actual distribution of assets can take place within the matter of weeks, if not months. So if there's a house, the house will be sold, and then the proceeds of sale distributed. There's not these court filings and court periods of time that have to be, complied with before the assets can be distributed. A very big advantage. So a revocable living trust, the major advantage is the avoidance of probate, and that is a critical aspect of doing it. So for many of our clients, they like to do the revocable trust. So if they're doing a plan that involves elder law planning, they may have both a revocable living trust and an irrevocable trust. They will transfer to the irrevocable Medicaid Asset Protection Trust the assets they want to protect, and then the assets that they want to retain control over, they will keep in a revocable trust. So for example, if you have a revocable trust, an irrevocable Medicaid Asset Protection Trust, and you have an IRA, on your death, there will be no probate. The assets in the irrevocable trust will go to the named beneficiaries. The assets in the revocable trust will go to the named beneficiaries, and the IRA will have named beneficiaries, and those assets will pass to them, again, outside the scope of probate. There will not be the expense, the cost, and delay of probate, which is a very big factor. Now, again, some individuals don't mind the expense of probate, but frankly, I don't see what the purpose is. When you can avoid probate, I would say avoid probate, because it can always raise problems and issues. For example, a last will and testament is much easier to challenge than is an irrevocable trust. It is much harder to contest or challenge a revocable trust than it is to challenge a last will and testament. So that's something to keep in mind. And again, the time factor, the delay of the process of going through probate is significant. So in order to avoid that process and avoid the expenditure, the legal fees of probate, the filing fees of probate, then you really need to consider utilizing a revocable living trust. And I've been using it for several decades now, and I find it to be an excellent planning vehicle. As I said, many of my clients like to combine it with the Medicaid Asset Protection Trust. They like the idea of when they pass that there's not going to be any probate. So to make sure that there's no probate, the key element once you have a revocable living trust is to make sure that the assets are titled in the name of the trust. So your house would be deeded to the trust, your bank accounts would be titled into the name of the trust. And the same thing applies if you're doing an irrevocable Medicaid Asset Protection Trust. And again, that's another type of vehicle, another type of trust vehicle that will avoid probate for the assets that are titled in the name of the trust. And this trust, the Medicaid Asset Protection Trust, is one that we use for clients who want to protect their assets from the cost of long-term care, whether it be home care or nursing home care. They're concerned about protecting the assets from those expenses and costs. What kind of other trusts can you do? As I said, we have the revocable trust, we have irrevocable trust. You can also create a trust for your grandchildren or children. A lot of parents like to make annual gifts to their children and grandchildren. However, they're concerned that if they put those annual gifts into the names of the children and grandchildren, they won't be properly used. They'll be misspent. They'll be spent on foolish items. Whereas if they transfer the assets to a trust for the benefit of the child or grandchild, they know that those assets will be there and will be controlled by the trustees of the trust and can be used for the benefit of the child or grandchild, either during their entire life or until they reach a certain age. For example, a lot of clients used to use the UTMA accounts, the Uniform Transfer to Minors Act accounts. And over time, parents would have saved significant amounts of money. I've had a number of clients come to me and said, gee, I've got an issue. I've got my 18-year-old daughter who has $200,000 in an UTMA account, and they're now getting close to the age where they can remove the monies from the UTMA account, and I'm concerned that they're going to spend that. Well, in those cases, sometimes what we have the child do, the child creates a trust and transfers those assets to the trust so that they're not going to be spent and misspent. Again, obviously you need the child to agree to this, but that's another vehicle that we use. There are trusts for life insurance. If you have large life insurance policies and you want that policy not to be taxable in your estate when you die, you can have that policy owned by a trust, an irrevocable trust. And when you pass away, the death benefit from that policy will pass to your named beneficiaries under the trust and not be part of your taxable estate. So again, that's for individuals who are more concerned about estate taxes. Very small part of the population really has an estate tax problem. The biggest problem most individuals have are making sure that their assets pass to the individuals that they want them to pass to, that their estate will be properly administered, and they have the right named individuals, whether it be a trustee or the executor of their will. And by the way, you should know that even if you do a revocable living trust, we still do a will. It's not your typical will. It's what is called a pour-over will. It says, just in the case I die and I have assets in my name alone, then my will would control those assets, and I want those assets to go to my revocable trust. So it's commonly referred to as a pour-over will. So even though you're doing a revocable trust or an irrevocable trust, we always still do a will for the client because of the possibility that they could die with an asset in their name alone, and that we want that asset again to be conveyed to whomever they want. And in this case, it would be to their revocable trust. So from a planning perspective, the use of trust are very important. I would suggest to you to look into them. We have numerous articles on our webpage, esslawfirm.com, about revocable trust, irrevocable trust, Medicaid asset protection trust. So you'll see plenty of articles there about these different trusts. And again, if you have any questions about the trust, please feel free to give me a call. My office number is 948-1500, or you can email me at a.enea, E-N-E-A, at esslawfirm.com. Again, I hope you're all well and you're staying safe and healthy. And if we can ever be of any assistance for your elder law, long-term care planning needs, Medicaid needs, please feel free to reach out to us at Enea, Scanlon, and Sirignano. Thank you very much and have a great afternoon.